when a temporary restraining order is granted, within the family code, it says a judge has 25 days to set the initial hearing. Most judges push right up against that. They have busy calendars. They don't want to deal with it. They're going to slide it in as late as they possibly can. But you're going to have a 3 to 4 week period where this restraining order, no matter how bogus it is going to be in effect. What is going on, everybody? My name is Mark Reel Jr., the Father's Rights Attorney, and you are watching another episode of the Father's Rights Playbook. On today's episode, I have partner here at Real Father's Rights, Ryan Dreyer. Ryan, welcome in.
Thank you, Mark. Happy to be here.
Awesome. And then today, for our listeners and viewers, we are starting a 6-part series. And this 6-part series is going to be all about what we wish our clients knew when they came to us and they'd been served domestic violence restraining order paperwork. So we're going to spend the next 6 weeks going into different details, different areas of domestic violence restraining orders in hopes of educating you and preventing you from making mistakes that we see that are very costly to a lot of our clients. So on today's episode, we are going to start out and talk about the TRO. And I'll start out by saying this, Ryan, is a lot of people, until they get into the system, don't realize that the domestic violence restraining order request is the only court document in family law that the courts will actually help you fill out. So this is a document that you go to the clerk's office, and they're going to tell you what you filled out wrong, what you filled out right, what you should add. They're going to actually give you all the forms for free. If you went there and asked them to do that with a request for child custody, they tell you to get lost. But with a restraining order, they know exactly what needs to be put and how it needs to be put to look good in front of the judge. So that's where I always start out with. This is the easiest filing. We see a lot of restraining orders that are filed because it's easier to get a child custody order from a domestic violence restraining order filing than it is to file a petition and file an RFO. And it happens in hours, not months. All right, Ryan, so we're going to start out with this. An individual, we know about 90% of the time it is the female goes and they file this request for a domestic violence restraining order. It's an ex parte filing, which means the responding party, the restrained party, however you want to refer to them, they don't get a chance to respond. It goes into judge's chambers and the judge makes a decision on whether to grant a temporary restraining order prior to the hearing or to deny it. Now, the vast majority of the time we see the TRO get granted. For our listeners, what is the standard for getting this TRO granted?
Whether sufficient evidence has been put forth in the pleading papers, which is almost anything, that domestic violence has or was likely to have occurred. So very, very low. Based on any allegation, they don't look at the trustworthiness of it or almost anything. If they allege a threat, if they allege violence, it's going to be granted. Right? And so basically they're going to look at their pleadings and they're going to take them at their word. They're really, unless it's just obvious on the face that, hey, this is just custody, this isn't actual domestic violence, they're going to grant it. If there's a chance, if there's an outside chance, they're going to grant it. I once had a TRO granted where the opposing party said that my client had hit her window of her car when she was driving at him. So, I mean, it's a very, very low standard. And the reason is, no judge wants to deny a TRO and an actual incidence of domestic violence occurs afterwards, right? So it is a very, very low standard. Like realistically, they could say anything if it qualifies as a threat, sexual violence, physical violence, stalking, disturbing the peace of the other party, which is the catch-all. Well, we'll get into that in another episode. All they have to do is, again, plead one fact that fits within Family Code 6203 or 6320, and they get it.
Yeah, I always tell people it's essentially they look at the pleadings, and if anything in those pleadings constitutes domestic violence, the judge has enough to grant that temporary restraining order. And they aren't going to take much context. I mean, some of the good judges, I once had a case where mom had went and filed a restraining order on her own. The TRO got denied because in her pleading, she admitted she was the aggressor. So yes. Outside of situations that are egregious like that, they leave out your side. They don't tell the truth. They make up facts. They stretch the truth. It doesn't matter if on the face of the pleadings, there is sufficient evidence that domestic violence has occurred and there's an ongoing threat or danger, they will grant the temporary restraining order.
100% they'll grant it without even a thought on how that would affect your life. Whether you're going to now be homeless for 21 days. They don't care if you don't have family or friends here. They don't care if you have the financial ability to get something else. They don't care that you are a great father or that you've taken your kids to every doctor's appointment, everything else. They don't care if the other side actually had a substance abuse issue because they don't know. They don't take any of that into account. And so you can have people, if they are willing to game the system, it's a short-sighted strategy, but it is a strategy. They're going to get that restraining order. So if they're willing to lie, they're going to get it. They're going to get it. And that's why we have a hearing thereafter. But it is tough and it's harsh. Very harsh.
Yeah, unfortunately, statutorily, you have about 3 weeks, less than a month, where a judge has to schedule that initial hearing, which in theory, if you're ready to go, is your trial. So thankfully, it's not very long, but that 3 to 4 weeks can be a very, very long time for guys. And to roll back, what Ryan and I are referring to is when a temporary restraining order is granted, within the family code, it says a judge has 25 days to set the initial hearing. Now, most judges push right up against that. They have busy calendars. They don't want to deal with it. They're going to slide it in as late as they possibly can. But you're going to have a 3 to 4 week period where this restraining order, no matter how bogus it is going to be in effect. It may kick you out of the house. It may prevent you from seeing your kids at all. You may not even be able to go get your car keys or your clothes. There can be so many restrictions. Now, a judge can piecemeal it together, and a lot of times you'll see them create some carve-outs to, in quotes here, make your life a little bit easier. But for the most part, they will blanket grant them, and they'll deal with it when it comes in front of them. So, Ryan, for this, probably the number one mistake we see made when it comes to these just absolutely bogus restraining order requests is violating the restraining order. So for our listeners here, what happens or what are the ramifications of violating the temporary restraining order?
Oh gosh, this is the one that infuriates me because a lot of times they don't understand the nature of the restraining order, which means you can't send a text to other people saying, hey, can you tell Susie to know this, or reaching out indirectly, or having a friend reach out. They don't understand. And let me tell you guys, I have defended numerous restraining orders where I proved everything to be false, and they would have had that restraining order dismissed, if not for one stupid action. Yeah. And it doesn't have to be negative. It can be like, I can't believe you filed the restraining order, or I wish you and the baby the best, right? Anything is a violation. It doesn't matter what your intent is. Maybe we can use that to mitigate later, but case law says a court has the discretion to order a restraining order based solely off of violations of the temporary. So you cannot, I don't care how bogus it is, how unjust, you can't call their parents up and say, hey, tell Susie to say this.
Yeah.
You can't do anything. No texts, no emails, no TikTok, no FaceTime. No.
Don't drive over there to talk it out with them.
Don't drive near and just to see, I just wanted to see who was there, right? I thought she was cheating on me. Remember, you can't do anything. Don't do anything. Respect the restraining order. You have to respect the restraining order.
Yeah. So in short is any violation of the temporary restraining order can allow or does allow a judge to grant the permanent restraining order. And most judges are pretty liberal. They don't take too kindly to people not following their orders. So it's not going to put you in a good light, even if it was, in your eyes, a minor or harmless infraction.
Correct. And that really even means custody. So say that your kids are mostly with you, the other side gets a restraining order, and you say, well, the police come and say, well, my son does not want to go with his mom, and so I'm not going to make him. All right, cool. Well, you're probably going to be found to have violated that restraining order. Yeah. It's a sticky situation, and something like that, please get legal counsel so we can try to address that. I mean, if your child is put in a dangerous situation, then let us go in ex parte and try to fix that if it really is. And the judge is only going to grant that in the rarest of circumstances, right?
We have seen it though, where a mom or a dad is the non-custodial parent, really isn't in the kids' lives, files a restraining order. There may be no court history. Maybe there's not an active court case. There's no court orders. So one parent just files a restraining order against the other alleging domestic violence. It gets granted. The judge gives custody to the parent who filed the restraining order, even though I think the most egregious, I had an instance where mom had not seen a 4 and a 5-year-old in more than 9 months and hadn't spent real time around them in over a year. She went in, filed a restraining order, got custody the next day. And even in that instance, we filed an ex parte saying, hey, he has full legal and physical. She knows nothing about their medical. She knows really nothing about them. She doesn't take care of them. And the judge still kicked it down the road to that initial hearing.
No self-help, people. No self-help. Come to us for help. Come to counsel for help. Let them try to navigate it, because it's so tough, especially when you have issues of custody. And sometimes you absolutely have to move for the health and safety of your children, but you can't make that decision. I can't stress that enough. No unilateral action here, right?
Definitely.
Follow the restraining order, no matter how much it grates you, how much it breaks you. Follow the restraining order and let us figure it out. Let us get to a real trial and take care of you.
Yeah, definitely. Well, Ryan, thank you to our listeners and viewers. I hope you found this informative. It gave you some good insight into temporary restraining orders. If this is something you are interested in, that you want to learn more about, we're going to have 5 more episodes this month covering all things domestic violence restraining orders. For now, we'll see you guys next week. My name is Mark Real Jr., the Father's Rights Attorney. We'll talk to you next time.